Well, good afternoon. Good afternoon. Here we are at Monty and Ramirez, Sarah Monty and Attorney Saif Ali, hoping to spend a little bit of time with you, just letting you know and giving you updates on business immigration and, from petitions to policy, the latest on what's happening with business visas and in compliance. Okay. Um, let's see. Safe, why don't we go ahead and look at what we're going to be talking about today?
Sure thing.
Okay. So I will be presenting on the first three subjects, and that's basically it's a curtailment of humanitarian immigration programs and the impact to employers. Now, typically, when dealing with non-immigrant visas and immigrant visas, we really don't get into the humanitarian visas, right? But this year, they've come front and center for, I think, most employment-based immigration practitioners because we've got employers really concerned at the number of folks that they're losing, and it's trying to help guide employers through that, uh, the termination, the challenges to the termination, the response from the appellate court. So we thought it was important to touch upon this. Um, and then we're going to be talking about the H-1B modernization rule. And actually, remember, this is the modernization rule that actually came in January 2025. This was actually a Biden era modernization rule. And we're going to talk about it because I think there's a lot of folks out there that aren't really aware that this is the law right now. We're going to talk to you about the good things, the bad things, and maybe hoping that this area really doesn't change too much because we're seeing such shifts, such changes. We're hoping that this will keep the issues for H-1B employers a little bit stable. So we'll be diving into that in some detail. And then I'll be talking about the H-1B Trump changes. We know that um, there are a lot of the folks within the Trump organization are against H-1B visas. We're going to be talking about some of the proposed changes. Again, these are proposed, but things that employers right now have to start thinking about. Um, we're in the month practically of September. We've got the H-1B lottery list that people are starting to assemble now. Well, there's a few pointers we're going to be having, even though we haven't had the changes take place yet, but there's some things employers have got to be aware of. Okay. And Safe, what are you going to be focusing in on?
And what I'll be talking about is beyond, the H-1B, there's been changes in policies across the board. That includes NIVs, which is what we call non-immigrant visas. So that'll be your TN visas, your Ls, your Os, all the other different programs that employers like to use. Some of those are facing impacts too now. There's been a lot of changes to the USCIS policy manual under this administration. And what we want to do is talk about some of the impacts that are going to affect you as employers and employees and what you'll see, as part of that. We'll also talk a little bit about I-9 trends and general agency trends, and that's going to be all the different agencies we deal with in immigration. That's going to be Department of Labor. It's going to be DHS, which includes USCIS. It's going to be Department of State. And we're also going to be talking about how I-9 enforcement and auditing is shaping up, which is really mostly under DHS's purview. But in general, how these executive agencies are now functioning under the Trump administration as these policies have started to take place. You might recall, I know some of you guys are repeat invitees to our seminars. We've been talking about forecasting and what policies would take effect. Well, we're starting to see the kind of policies that really are being implemented now. And we have a little bit of a better idea of what we're seeing with the agencies. So we'll dive into that issue and talk about what we're seeing, what we think we might be seeing, and the challenges that employers are facing because of it. So that's the area that I'll be covering, and I think we're going to dive right into the first issue, which is going back to the humanitarian immigration programs and their impact on employers.
Okay, great. And what I wanted to just mention before we dive in here is that we're going to be having some other seminars in about the next month. One of the seminars that we have is it's again family-based immigration policies, and I know that there's many, even people in HR are very interested in seeing what's happening, what's changing. We're going to be coming with more information on that, and as well as an I-9 employer and update, but this is going to be in Spanish. This is for the small employers um, that may not be, may not have the I-9 practices in their mind as, things are heating up from an enforcement point of view. So that one ought to be really interesting. Again, that one is focused for the small business on I-9 practices, and that one will be in Spanish. Okay. Well, anyway, let's go ahead and begin here with what is it that's happening? Why is it that non-immigrant visa attorneys are now looking to see what's happening with humanitarian visas? Okay. And what we've seen here is, I think, is we've had a real rejection from the Trump administration regarding all those humanitarian classifications, especially the parole programs that were brought into place by the Biden administration. Okay, so what we've seen, and I've never really had this. I don't think I remember ever seeing that. Is we have an employment authorization under maybe one of these parole programs, and suddenly we find that we have the revocation. And this has really caused lots of angst for employers because especially if they're I-9 employers, because suddenly you're getting notices that this employment authorization that looked good and is revoked. So we basically have had that happen, and specifically those humanitarian programs were under the CHNV, the Cuba, Haiti, Nicaragua, and Venezuela program. Those EADs were revoked. Okay, now the case is still in the courts, but basically the administration decided to go ahead and revoke that. We'll see how it shakes out. But for right now, employers have been told that, again, these are E-Verify employers. There were actually notices that went out to these E-Verify employers telling them and notifying that these individuals, they could no longer count on their employment authorization. Okay, so that was actually a very rough a couple of weeks for employers. We've had the TPS rollbacks. Like again, the TPS rollbacks, along with all the challenges that come with that. Okay, so the administration is revoking temporary protective status for up to 563,000 individuals across the countries, including Haiti, Honduras, Nicaragua, Venezuela, Afghanistan, Cameroon, and Nepal. Okay, so what we've so here, these are the TPS. It's not under the parole programs. We've had those. Again, so going to be challenges. So as an employer, where do you look? What can you rely on? Well, you're an E-Verify employer, you would have gotten those notices. Those individuals that are, those companies that are not on E-Verify, we're telling you if that you've heard of nothing else, I think you can go ahead and depend on those expirations, right? Because you've not been notified. Here, E-Verify employers were actually specifically notified regarding those individuals that those employment authorizations that were revoked. Okay, but for the final word in USCIS has been very good about updating their temporary their TPS page or the different parole sections. What you do is you just go directly to USCIS and look to see what's happening. Now you'll have to read through it a little bit, And while the administration kind of does put their spin on it, they will let you know there in the text whether you can, what is the state of what does the law say regarding these programs or the TPS program in itself. Okay, so so this is just again, we decided to include this in here because it really did impact us. It impacted employers. And yes, these aren't immigration sponsored visa classifications, but they are a vital part of our workforce. I think in saying that there's been approximately 1 million individuals that have lost employment authorization over the last year. So it's been very impactful, very, very impactful. And so we've got these programs. We're going to see if any of them actually are able to survive. SAFE is going to go into this area a little bit more regarding, compliance and what employers have to do and but it has been a very challenging period of time for employers. Okay, but we're going to start up with that. Let's go ahead and go on to the next slide and talking about the H-1B modernization rule. Okay, so this again, there's a little bit of, just as a reminder, is that this was actually part of the last legacy of the Biden administration. And we probably shouldn't say that so loudly because I bet you there's a lot of individuals within the administration that probably don't want to give credit to that. But this actually was, I think, an important piece of rules that were set up just so that we get some clarity. Okay. Now, under this rule, amended petitions are required before job changes. Okay. It used to be that if there was a substantial change in the job offering under the H-1B program, well, then all an employer had to do was basically put the government on notice, right? That this individual had maybe changed workplace, maybe this individual had been promoted, maybe there had been a lateral change. That amendment process was simply, you had to put the government on notice. So there was no requirement that this amendment had to be filed before. It just had to be done at some point, okay? And frankly, sometimes I think employers sometimes used to push the envelope on this and maybe, not notified it soon enough. But now under this rule, these amended petitions are required before job changes. Now, this has caused a huge issue within companies where you've got managers that aren't used to this rule, okay? They're not used to notifying the legal department or the HR department or however these changes are handled for each employer. They weren't used to really keeping track of something like this before it happens. Okay, so HR folks, people who are out there working with this issue, it's so important to just remind managers that this has to happen before the job changes, okay? And one of the places that we've seen this play itself out is that we also know that we've got a lot more vetting at the Department of State level. So we're kind of hoping that we don't see some negative fallout here. If you have an employer that didn't timely change, didn't actually notify the government before the amendment took place, and this might catch up with the employee at the visa stamping. So we're, keeping our fingers crossed. But here, so important to notify the manager, the business managers of this important requirement. Okay. There's also been a new definition, or I don't know if it's a new definition so much as a clarification of what a specialty occupation is. A specialty occupation not only requires a bachelor's degree, but the bachelor's degree must be directly related to the specialty. Okay. Now, those of us that have been working in the H-1B area for rules, we've actually, I think most of us has started to do this because we wanted to avoid requests for additional evidence. So in the case, if you've got maybe the typical case is, let's say that you've got an individual with a business degree working in software development. Well, what even though you might have a person with a real business degree, a bachelor's degree in business, that bachelor's degree in business is not really related to software development, right? So the idea is, and I think that most of us have been doing that, is to go ahead and get an evaluation so that maybe you're able to get an equivalency of something that's maybe it'd be business analyst related to software development. You're going to have to cover, get over the bridge. Well, under the H-1B modernization rule, now they're insisting upon it, okay? And I guess, like I said, most of us have already been taking care of this, but now this is actually codified into the rules that it must, not only is it must be a bachelor's, but it must be directly related to the job opportunity, okay? The next thing that's followed, and again, this is another area of concern, is that maintenance of status evidence is required to process transfer extensions or amendments. Again, people working in this area, we've been doing this. We've been proactive about doing this. And what does that mean? Well, that you're going to want to make sure that that individual that's being transferred to your new employer really had been maintaining their status. And how do you show that? Well, they're going to want to see the pay slips, right? They're going to want to be able to see that they were employed and they were working, and there has been a maintenance of status. Or in the F1 to H-1B scenario, it's, are all of those I-20s really telling the story? Are all of those I-20s up to date? So, again, service has been RFEing folks for this, and I think most individuals working in this area have really made sure that this is happening. But now this is the rule, right? And this is a way to get and keep from getting those nasty RFEs. Okay. There's also been the expansion of regulatory and inspection powers. Okay. So the government has basically said that they will have the verification of all information provided by all means necessary. So if that means that you're going to have the FD&S officers, those are the officers that you pay $500 for with your filing fee. You're going to be paying for those folks to maybe making site visits at the work site, and maybe your H-1B employee is working at home. Well, they're saying any means necessary. You might have those officers actually checking the work site, which may be the home. How does this play out in today's world? Well, guys, unfortunately, you've got to understand that the administration is aggressively enforcing immigration laws. That's what they're doing. They've got a target, and that target is 3,000 arrests a day. And let me tell you what we've seen. We've seen, USCIS was always able to issue NTAs, but we've seen an uptick. We've seen USCIS aggressively asserting their ability to file those NTAs. I think you're going to be having certain officers looking for low hanging fruit. And if that is that maybe there's a work site that's been listed on the LCA, is not really manned by an H-1B employer, well, then I can imagine there's going to be some pretty aggressive action. Again, 3,000 arrests a day by any means possible, and you're going to find that that you're going to start seeing that. Okay.
So
Let's go
Sarah,
on.
would it be fair to say that there's some concerns with hybrid work that we've been seeing in our practice and some concerns about remote work that have cropped up, especially in H-1B?
Yeah, I think, and Safe, I'm glad you're bringing this up, is that I've always been a little bit nervous about employers having such a liberal policy regarding hybrid work opportunities, because you see that whole business of changing and maybe going from a Houston, Texas MSA to, Santa Clara, California, which I believe is one of the most expensive places to actually take an H-1B employer. So with kind of a loosey-goosey, hybrid policy, you're having employees move, and maybe they haven't notified their employer that they've moved. And as a result, you don't have an amended petition filed, and you might have an FDNS officer going and knocking on a door someplace in Houston when that person has already left to Santa Clara. So I think that they are going to be exploiting this lack of connection between, HR or legal and management. And I think that we will see some activity here. Have you seen anything else in this area?
So one of the other things is, of course, there's always wage issues that arise with H-1B, because in the H-1B realm, wage is based on locality. And so, while employers, and I understand from, the employer's perspective, it's great to have that remote policy because it helps you attract talent. It's attractive for many younger workers and workers in general, not just younger workers, everyone likes to work from home from time to time. I know I do. But with the H-1B specifically, because there's a locality issue when it comes to determining pay, if an employee is working consistently out of a different location, I mean, from Houston to Santa Clara, for example, wages are higher in Santa Clara than they are in Houston, generally speaking. And so, it may be a departure from your original LCA where you were paying fair wages based on the Houston standard, but all of a sudden you've got employees based in different localities, and they may be really fluid in when they move, and there might be a disconnect there. So not only are you coming into a compliance issue when it comes to listing work sites and possible FDNS investigations, but you're also inviting Department of Labor scrutiny because there might be wage issues coming up because you're paying fair wages for Houston, but the employee's no longer in Houston. They might be somewhere else, like California or New York City. And so it's important to make sure that if you employ a great number of H-1B employees, that your remote and your hybrid work policy takes this into consideration.
Yeah, and with that being said, I think it's really important that this information be explained to the managers, right? To understand what is at risk here, and to the foreign nationals, okay? The foreign nationals' failure to disclose this information in a timely manner, there's got to be enough time to be able to get that petition filed. That could really cause problems. And I think that if I were a nice officer trying to, get my quota of arrests that I need to get done, I would look in this area, because I think that we are not, we're a little bit too loosey-goosey in this area, and I think that there's going to be, someone's going to have to pay that fiddler if things are not done correctly and properly. Let's see. Let's go on to the next. Let's go on to the next slide. And you know what? There's, in life and even in the H-1B practice, there's some positive effects, and I think it's important to sometimes we got to search a little bit, but under this modernization rule, there was a gift here, and that was a cap gap automatic extension until April 1st of the fiscal year. If you remember the days when you've got all these lottery F1 folks that were moving into the H-1B, but let's say that you just don't have any more, the cap gap used to end September 30th. And I know Safe and I would, there was flurry of activity. The H-1B was filed. There's no more cap gap status, but what do I do? What do I do? Well, we used to have to terminate folks after September 30th until their H-1B was ultimately adjudicated. And again, these were for cases that weren't processed with premium processing. Well, one of the gifts under this modernization rule was that that automatic extension was extended until April 1st of the fiscal year. And I think that really helped because, what is that? A premium processing fee? Is it 2,800?
It's a lot of money. Yeah,
It's a
2000.
lot of money. And if there's a way of being able to postpone that and knowing that you're not going to lose a vital person on September 30th, that's extended to April 1st, that's really big, I think. And so I think as a result of this, with that 2,800 plus filing fee, we've been able to confidently let employers know, well, you know what, there is this option. You've got, what is it, six more months, and give the service a little bit of time to actually take care of those. And so that you don't have to, let a bunch of people go. So F1 students who are beneficiary of CAP subject H-1B petitions requesting a change of status to H-1B gets that automatic extension. Okay. So that was actually a real plus. And I think that that was initially kind of overlooked, I know, and again, that's been a good part of what this modernization rule brought. And this next part is the deference policy has been enshrined in for how long, I don't know, but this was actually one thing. Safe, you pounced on this too. Is that the deference policy states that if I have an H-1B and I'm with the same employer with the same position and I filed an extension with that same employer and it's the same position for the same employee, well then if there was an approval, right, of that petition previously and there's been no change except, a change in the prevailing wage, which, that changes, every filing. Well, then if there were no red flags previously, then, they shouldn't really find problems with the next one. And so basically, I think that under these new regulations, there's the expectation is that there shouldn't be a witch hunt on your petition if previously they approved it. Now, with this, I'm interested to see what happens here. I wonder how long this is going to last. But for now, I don't think we've seen a lot of negative movement, have we?
I don't think so either. Yeah, I think so far USCIS has been fairly reasonable, I would say. I haven't seen anything that's, I would say, that's a little bit overreaching. But so far it seems like generally where things are remaining consistent with H-1B petitions, USCIS seems to not be finding issues or not going out of their way to find issues with it.
Yeah, so that does give a little bit of comfort, okay? And again, it is part of the regulations. We'll see how long it lasts. We'll see how long it lasts. Okay, let's go on to the next. So, the H-1B modernization rule, again, the codification of all practices. Third-party placement roles must be in a specialty occupation. Okay, so every time we're going to have a third-party placement, and again, that you're going to have whenever we prepare third-party H-1Bs, you know what? There's a heightened standard because there's going to be more scrutiny because there's the expectation from the government that maybe, this position is not a specialty position, or maybe the individual isn't being supervised, by the employer, the petitioning employer. So the H-1B for third party are always going to be, I think, more scrutinized. There has been the elimination of the itinerary requirements for the H-1B program. That used to cause kind of a headache, the way business practices are. You might have different layers of contractors, and sometimes that was very problematic. Well, that has been eliminated, okay? Streamlining revocations of H-1B petitions when employers notify USCIS that the beneficiary is no longer employed by the employer. This has been shocking how fast this is happening, because it used to be we would file these revocations And, it would take months, sometimes, maybe even a year. But now we have been seeing those revocations in basically within the month.
Even
And
faster, I would say, like within weeks, 2 weeks sometimes.
so, from that point of view, I feel better for in working for employers that I'm able to show that that file has been closed out. Not only has the withdrawal been submitted, but it's been acknowledged through a revocation. So that I think has really been a great has been good for the employer. But I know the other side of that, the flip side of that, is that information I'm sure is going to be used against the employees. Again, they're looking for low-hanging fruit. So if you've got a revocation that you've received on an employee, if I were, working for ICE and I needed to come up with my quota of arrest, I probably would go down that list and go and check out or to see what's happening with the foreign national. You know, that whole 60-day grace period, and again, subject, people think that it's a matter of right. No, that 60-day grace period, it's up to the discretion of the government. What's been happening with that employee? Have they found a new position? Have they left? If they haven't found a new position, it's pretty easy to be able to check that from letting the computer kind of check that. And if not, then maybe to go and make a visit to find out what is it that's happening. So I think that, that streamlining of those revocations, I think that it could possibly mean negative things for the H-1B employee that's transferring or looking for other opportunities. Um, the other thing, which I thought was very civilized, the explanation notices that is provided by the government when an H-1B is approved for a period less than what was requested in the petition. So let's say that you've counted all the days that the individual has spent outside, and you do your math, and math has never been very good for me, and sometimes we're off a couple of days. I think the first time we received that was kind of funny, huh? It was very, very formal language where they were basically saying, so sorry, you asked for October 5th, but we've done our math and we can only give you to October 1st. So that I think it's been helpful. And I like that they're doing it because if not, with these, when it comes to the adjustment period, it becomes a little overwhelming to, try to show a maintenance of status for the entire period. Okay. So this is basically what we have with the modernization rules. And I think it's a good deal. Okay, so then let's go ahead and see what we have with with the H-1B and I know that we were kind of I don't know, I was feeling good about in some aspects when President Trump was buddy buddies with our friend Mr. Musk, right? Um, because what did we think? Say if we said, okay, the H-1B visa maybe is
Yeah.
going to be okay because
Yeah.
Musk is a real H-1B guy, right?
And his company's Tesla, I'm not sure about SpaceX, but I know Tesla really does utilize the H-1B program quite a bit. So we were hopeful as long as he was there and buddies with Trump, but unfortunately, I think
Right,
that's
right.
changed.
Because we do know that within the administration, there's a lot of people within the administration that hate H-1Bs. And and we were very, with the America First program and the philosophy, which we're seeing being played out uh, every day now. We were concerned. And then, seeing Mr. Musk, when he was friends with President Trump, I felt a little bit better about it. But now that that relationship is over, um, now we're kind of sitting on edge. We're sitting on edge on what is going to be happening, and knowing that there's a lot of people within the administration that would like nothing better than to see the end of the H-1B program. Okay, let's go ahead and oh, you know what? This one I think is, can we go on to the next slide after that and we'll come back to this one. So these are some of the proposed H-1B lottery changes. And again, these are proposals. So let's not get let's not get a little bit, nervous about what's happening. These are proposals, but I think there's some of them that employers have to know about. And you know, our employees right now are starting to assemble their H-1B lottery rules lists, for a lot of those F1s that are showing promise that they want to go ahead and put up for that lottery. Well, I think that we've got to keep certain things in mind. Again, these are proposed changes, but they could mean a difference. And one of them is the weighted selection process for CAP subject H-1B petition. Okay. So what that means is that there's a proposal, they're looking at it, that maybe those limited visas, 65,000 regular plus a 20,000 US masters, maybe those positions, instead of the lottery, let's let the H-1B go for those individuals who are making the most money. Okay. I don't know. That's one of them. So what would you do in that scenario? Say, I think let's say you've got a marginal sponsorship with somebody that's a level 1 and maybe right at the prevailing wage. You know what? That person might be somebody that may not make it in the end if this comes to pass. Okay. And so, one of the other is to eliminate the lottery process completely. And again, uh, uh, award these visas based on pay. And then so these are this could be a real disadvantage to the international students, okay, who are not going to be able to make that. And then let's go on to this, because you know what? I'm just seeing that I'm going over. Here, Safe, why don't you go ahead? This one I think was actually more along your area regarding the more aggressive border screening. Tell us what's happening there.
So some of the scary things that we're seeing really when it comes to aggressive screening. When I say border, I don't just mean the land border, I mean airports as well. And this affects workers and employers and everybody, because if you depend on an international or a global workforce, you've got people going in and out of the country, they go on vacation, they come back. Well, there's a lot more screening that's going on, and it's stressful for workers, it's stressful for everybody. And unfortunately, we're seeing visa revocations for what you could call really silly things. Some things you might even call free speech violations. Things like, for example, personal device searches. Well, that's not really a free speech violation. Officers can and do look at um, personal devices of employees that are coming in. They can access phones and laptops and social media content. And right now, they're on the lookout for certain types of social media content. And that can be, issues that are very relevant to today. For example, I've got this image of a meme of President JD Vance, and it turns out this
You
meme
look
actually.
familiar. I was wondering.
So there's a meme going around where people make all these ridiculous photos of JD Vance, and they're all crazier than the last one. But this a Norwegian man was found with this photo in his camera roll and his phone when he was coming into the United States, and his visa was revoked for it. So
Wow.
those are the issues that we're seeing, because you think, well, this is just a silly photo, but turns out the person lost their visa, and part of the executive orders that we're seeing now is to root out anti-Americanism,
Anti-Americanism. Yeah, I just saw it. Yeah.
anti-Semitism. And so there's issues that the officers are on the lookout for, and very zealous officers might look at things that are fairly harmless, but turn it into a visa revocation kind of issue.
Well, right. And it becomes subjective, doesn't it? No, what's
Yes.
harmless,
Yes.
what's harmless and just silly banter, and what's anti-American. And so that's why what we're telling our employees is, look, if you don't have pictures of puppy dogs or kitty cats, because again, uh, there's a question of free speech. Is there free speech? Well, at the port of entry, not. Remember 9/11, remember the Patriot Act. So there's that's the only place on earth where you really can't have employed attorney representation, right? So you've got it, that area is meant to be able to root out crime and and possible terrorist attacks. So the government really leans in heavily, and they're doing things like that.
Yeah.
What
And
other kind of questioning are we seeing here?
And they're asking a lot of political questions, like I said, legal, diplomatic concerns, but they're also asking about proof of employment. So it's really important. And Sarah mentioned she's a really important point that there's no attorney representation at the border posts. There's no attorney representation at the airports. So it's important that if you have your workers traveling abroad, and it's a great idea. Please reach out to us. We're more than happy to help and prepare you, employers and employees, on what you need to do, what to take care of. Because not only are there questions about the contents of your social media, your political views, legal concerns, but they're also asking about employment. So it's really important at this time, make sure you carry your employment documents. That's your pay stubs, an employment verification letter that's very recent from your employer that says that you're transiting in, you're coming back for work, you've been working at this company, and or if you're coming in for maybe a business visit, to make sure that that's documented very thoroughly, that you have, if you're coming in for a job interview, that you're bringing a letter. So it's important to make sure that not only are you prepared in terms of all your documents are secure, but that you also have the documents you need to show that you're coming in for whatever intent you have. So if you're an H-1B, you're coming back for work, or if you're a B1 visitor, you're coming for a business visit. So those kinds of questions are being asked at the border, and it's important to be prepared before, because at the time you get to the border, it's already too late. Attorneys can't step in at that point. So it's important to be proactive when it comes to this.
Yeah, and just one other thing, and if you've got anybody, lots of B1s coming in for meetings, those are the ones that we really have to, make sure that they have sanitized information, making sure that they really have a business interest, that they're not actually working without
Exactly.
employment. Okay, good. Let's go on to this one. With this beautiful act, the one thing I just want to say about this one, because I know we're kind of running into time here, is that the biggest thing for me, and I say, if I don't know about you, but for me, the biggest thing with this one big, beautiful bill act was the almost $30 million of in enforcement that's going to be spent in enforcement. And they're going to use enforcement any way they can, whether that be at the port of entry, whether that be at the work site, whether that be, so those $30 million are going to get they're going to get something for that. What do you feel here was the most substantial thing
I
under
think
this act?
there was a gigantic package that went to ICE, and we'll talk about it when we get to our little audit and I-9 section, but compliance it's the big deal right now. Texas, we're not quite at the forefront of it yet, but California, other states, the things that we're seeing coming out of those states, it's pretty significant. And I think it's only going to get ramped up more and more because, like you said, Sarah, they're looking for 3,000 arrests a day, and they're only going to hit that number one way, and that's with more money, more enforcement.
Okay, so how about we just go to the CAP Act and let's just say a few things about that, because I do really want for you to get to the enforcement part. So what's happening here with the CAP, the College for the American People Act?
So for the CAP Act, really the important thing here is that and it's proposed legislation, so it's not there yet, but they want to remove the H-1B visa cap exemption for colleges and universities that hire foreign workers. So it's not going to go back and retroactively affect people that already have those visa statuses or those employment statuses. And then, of course, universities could continue to extend existing H-1B visas under the current rule. But what they're really trying to do, this all comes back to America first, is that they want to ensure that schools prioritize training and hiring Americans first. So what this is really going to impact is the cap exemptions for the colleges, for professors, people seeking to hire foreign talent for colleges and universities. And I really think it's part of this administration's really their crusade against universities and foreign students and foreign talent in general. Basically, the end effect of this would be that removing the exemption means that U.S. colleges and universities would have to compete for the same 65,000 visas under the H-1B cap, which they didn't have to do before. And that's going to really impact the quality of our education system, our universities. So it's a little bit worrying to see this, but it is a proposed legislation that we're going to be keeping our eye on.
And basically what they're just also saying, if that they would push people to use the O1 extraordinary ability or the J1. But still, I think this, again, proposed, we'll see what happens here.
Yeah.
Okay. Okay, this one, I think it's worth a mention here. This kind of hit the H-1B rejection and the potential denial for valid signatures. What is happening with that? I thought that scanning was allowed, safe. Is scanning still allowed?
So scanning is 100% allowed. But we have to be very careful with how we do it because what USCIS is looking out for is a scan of a wet ink signature and not a scan of a PDF signature. I know it's really easy to hop onto PDF, draw your signature, and just copy paste it onto the signature block, but that's not what USCIS is looking for. What they want is the scan of the original paper that you signed. And so the practice that we've been implementing in our firm is making sure that when we get the scan, we also request the originals because if USCIS questions the scans, then we have the originals ready to show. And we can't do it after the fact because the original has to match the scan. So if they see it's a completely different page, it's not going to work. And so it's important to make sure we retain those documents. Some employers like to keep it at their office and send it as needed. Some employers like us to have it. But it's important to, one way or the other, keep that original file on hand and make sure that you're doing this, you have your signature policy in place because it has to be, yes, a scan, but a real wet ink signature, not a PDF, not a DocuSign, not a drawn signature.
And you know what's important here is that it's not rejection. They are denying these. They are actually denying. And that's the part that's so, and now with technology, you've got signatures that look like they're real signatures, and you're almost nostalgic for the old days where you would want to turn the page to make sure that it felt that you could feel the ink there. Well, I think they're really cracking down on this area, and this is they're denying these. They are totally denying these. Go ahead.
Yeah.
Go on.
So we've also seen some fee increases, 250. This is part of the One Big Beautiful Bill Act. So there's been a $250 fee increase for most visa categories, indexed to inflation. So we're gonna have to keep an eye on it to see if it rises. The asylum program fee expansion, that one's already a little old. It's been in place for really the last about year and a half. So employers know about this. We've been dealing with it, but there's also an upcoming, maybe a new $1,500 adjustment of status fee, and that's really going to apply to applicants who are adjusting to permanent status in immigration court. So maybe not as much of an impact on employers, but like we said, we've been talking about humanitarian visas, humanitarian routes to residency. So it may impact some of your workforce, and it's just something to be cognizant of.
Do you expect to see more employment-based applicants fighting their case at the immigration courts?
I think we will, and we'll talk about it a little bit, but there's a worrying policy called the NTA policy, and we'll cover that. But essentially, there is a risk that we might see. We used to think that employment-based immigrants are doing everything the right way. They're not ever going to see the inside of an immigration court. But with the NTA policy, that I don't think that that's the case anymore. And we'll talk about it a little bit in our later slide. I'll run through and I'll run through some of the changes that we're seeing to these visa categories very quickly. The USCIS is updating their policy manual, so they inform us how they're going to be adjudicating these cases. For TN visas, we know a few things that we've really been doing already for a while, but they've really just kind of put it into place. For example, TN, which is the USMCA, the NAFTA agreement. Canadian Mexican citizens can obtain this visa for professional positions. You can't substitute experience. It's got to be a degree, except for management consultants. That's a unique one. Document translations. If you're filing with USCIS, you have to submit translations. You don't have to do it with Department of State, but you do have to do it with USCIS. If you're doing a job that requires you to have a license, for example, if you're an attorney and you have to practice in Texas, then you need a license. That's one thing that they've updated. But if you're non-clinical or you're not regulated or you're just doing something that doesn't require you to be licensed, then the license isn't required. Another one is a scientific technician, technologist. There's been some updated guidance on that. They have to be working under a professional. They have to be working in a theoretical area, engineering, science. But this is an interesting visa type. And if you're able to take advantage of this, we're more than happy to guide you because we've been doing a little bit, we've been doing a lot more of these scientific technicians. And it's a great way to get employees in a time when I think it's hard to find employees in
When
this.
they're not, and these are non-degreed.
And these are non-degreed. Yeah, this is a unique one
non-degreed.
too.
And so I think with this, didn't they actually match the FAM? So this is
yeah. So they've updated their guidance to bring it in alignment with the Department of State guidance. And so what they're doing now is that yes, we're hopeful that the scientific technician technology, that category is back open for business for non-degreed professionals. Now volatility, yes, we're going to be keeping an eye on it. There's a lot of trade wars going on. The NAFTA, USMCA are trade agreements, so we're going to be just keeping an eye out to see if anything changes with Canada, anything changes with Mexico, which could happen on a day-to-day basis with President Trump. We'll have to look out to see what kind of policy changes come into play. With O visa, one of the significant things we've seen is it's not really immigration related, but there was an executive order to called the Keeping Men Out of Women's Sports Act, which targets male or transgender athletes from entering to compete in U.S. women's sports. The O1 visa is a visa that's used by sports people, and so it may impact, transgender athletes or LGBTQ athletes who are coming to work in the United States or compete in the United States. We've also had some changes with the L visa. We've seen a lot of processing delays. The Edakuni settlement ended, so this is not just Ls, but also TNs and H-1Bs, which means that they're no longer adjudicating the family, the dependents cases with the principal beneficiaries cases. So we've had people say, well, my case has been approved, but my wife and child, their case has been pending for the last 2 to 3 months. And unfortunately, it's going to be that way because the settlement that we had that was in place till January is no longer in place. So expect those delays to be in place because premium processing is available for principal beneficiaries most of the time, most types of cases, but for the dependents, it's usually not. So we'll see those delays, and that's something we're going to see going forward. USCIS and DOS are experiencing longer processing times across the board. I'm sure you've seen all the news about federal agencies losing employees or firing their employees. That's part and parcel of this. Spousal work permit renewals, the automatic extension may drop from 540 to 180 days. So those automatic extensions that people have been getting from filing in the same category, they may not be as lenient as they were before. So there's always a risk of employment gaps, and it's important to make sure that as an employer, your employees are applying early, and if you're an employee, that you keep track of your expiration dates because you need to apply on time. We're expecting requests for evidence in the L visa category for it's really some of the major things that the L visa looks at. The 1 full year of employment abroad. So making sure you work with your foreign affiliate or your foreign parent for a full year, and that you worked for that full year in a managerial or executive role, or that you were working in a specialty knowledge role, and then you can prove that up. Documentation tips, what I've been advising clients is please make sure you prepare evidence of all of those things that your employee has been doing that makes them an L. If it makes them a manager, an executive, whether that's executive minute meetings, whether that's hiring, firing emails, proof of participation, proof of leadership, project approval, signatures on documents, all those things go to prove the L case. And when we see RFEs, those are things that can make the difference. So it's important to make sure you keep that documentation on hand. Another visa type that I'd like to talk about is the H-2A. It's still a viable option. It fills temporary gaps in agricultural labor. Just to give you a little background, there's two types of H-2 visas, H-2A, H-2B. H-2A is for agricultural, hence the A, and there's no limit to it. And that's one of the big advantages to it.
No cap limits, right?
No cap limit, which means that the H-2B, on the other hand, has a 33,000 limit with 2 lotteries in the year. It's much more strict. H-2A is strict too, but it's easier to get. If you're working in the agricultural industry, and this is a great way to get employees. So the H-2A, it remains a viable pathway. There hasn't been many updates. Every year, the wage limit, the AEWR, gets updated. So that's something to keep an eye on. And for right now, they're not going to be collecting certain fees related to the process, but we'll be keeping an eye out on that. Now, on the flip side, we've been talking about non-immigrant visas. Let's talk a little bit about immigrant visas and the residency process. Increased visa wait times across the board. I mean, it's gotten really a little atrocious at the Department of State just because the embassies are in chaos right now. They're cutting down on their staff. NVC processing times are up. There's also, of course, extreme vetting, so increased scrutiny, background checks, security checks, administrative processing, which is really a visa refusal, temporary visa refusal, we hope, until the case is processed, the security checks are cleared, after which, we hope for an approval, but a lot of people are in limbo. And like I said, the extreme vetting is really what's causing this, plus the shortages at the embassy. They're going to be thoroughly reviewing all previous immigrant history, and the DS-160, we're seeing a lot of review of old DS-160 answers. So it's important to make sure you work with immigration counsel, you keep that consistency, because keeping consistency is key. You don't want to deal with these kinds of issues at the consular post.
Because what would you be facing? Misrepresentation.
Misrepresentation, and that doesn't sink just that one case. It can sink your future immigration prospects as well. It's a very serious charge. Another thing we're seeing, and this kind of goes back a little bit towards H-1B, but it also affects the PERM process, which is related to the permanent residency, is that there's been a lot of wage volatility. So certain job titles have seen wage increases in cities like San Francisco, Seattle, and Dallas. So like I said, this goes back to your remote policy. If you've got employees that are working remotely in major metro areas, you might be having to pay a lot more than you originally thought. This is also the case for data scientists, web developers, computer systems engineers. Job titles are expanding. Sometimes the jobs are no longer considered professional. We'll talk a little bit about that in a second. But there's a lot of volatility in these job codes that we use for these non-immigrant visas and for the PERM process. So it's important to make sure that if you've got employees, whenever things change, something that was good last year may not be good this year because the Department of Labor updated their adjudication. So these are trends that we're keeping an eye on and things that may impact your future processing. For example, we're seeing computer systems analysts and computer systems engineers, CSAs, CSEs. These used to be considered pretty good, kosher, professional roles. That's not really the case anymore. CSAs especially are kind of a bad word, I would say, when it comes to now on the flip side, in TN, it's still a viable position, but you have to make sure it's a real computer systems analyst and not a software engineer or developer. Same thing with CSEs. USCIS has been a little bit more lenient on CSEs, on the engineers. There's more counter arguments available for us as attorneys to make. So that one is still viable, but it's something we're keeping an eye on. And of course, we're seeing changes across the board in the agencies. For example, USCIS DOS policy changes. We're seeing the visa bond pilot program. This is actually a temporary final rule. It's not in effect yet, but it's sort of a Empire Strikes Back. It's an old school rule that's coming back. It's a 12-month program that they're going to pilot. And the visa bond by alien, it's going to be essentially making B1, B2 applicants eligible for visa bond that they have to pay money to be basically it's their bond to ensure that they leave the US before their time expires. And it's going to be applying to nationals of what DOS is identifying as trouble countries, high overstay rates, people where the visitors do end up overstaying their
What is
visas.
that proposed amount?
I believe it's anywhere
30,000?
between 5 to 15,000 right now, depending on circumstances. So it's going to vary, but there's a range that we have, and it's 5 to 15,000. And so we're going to keep an eye on this pilot program and see how it really plays out because it is interesting that they're bringing it back. Now, of course, the travel ban has been in place for some time. Some countries are banned from full travel, full visa issuance. Some countries are only facing limited visa issuance. It might be limited, for example, no students, no Js, no interns or trainees, but maybe work visas are still allowed. So this might affect your employees on a country-to-country basis. It's important to impact, determine how it's going to impact each employee. So there's exceptions to the travel ban, and that we're going to be, dealing with these differently on a country-to-country basis. Now, this is an important part, and I do want to spend a little bit of time on it. The NTAs. The NTA is what's called a notice to appear. It's a DHS, Homeland Security document, which essentially is a summons to court, to immigration court. And previously, this was something that we dealt with in the humanitarian, the asylum, the illegal immigration, overstay process. Now we're dealing with it in legal business immigration as well. Because USCIS, their new policy says they're going to issue an NTA if they deny a benefit request, if the beneficiary is no longer in lawful status. And sometimes what this means is that extended processing times can often exceeding the 240-day work authorization period can put those extension applicants, change of status applicants at risk because there's a risk that once they're denied, if there's an NTA issued, all these issues are going to come up, maybe unlawful employment, unlawful presence, and it could be potentially very ugly. Now, there's an exception for principal beneficiaries. USCIS is not going to issue an NTA, even if the denial renders the beneficiary unlawful present. It does not apply if the beneficiary is also the signatory on the form I-129, and it doesn't apply for dependent family members. So that's important. It doesn't shield the dependents. So we may see cases of our legal employees. If there's a denial, they may be placed in removal proceedings, and they may be forced to attend court hearings. And people who leave before their hearings may be subject to all kinds of penalties, and they may damage their future prospects at immigration. USCIS is also enforcing the alien registration requirement, which is dependent children below the age of 14 are not required to be registered and fingerprinted when applying for the U.S. visa. Certain statuses don't get fingerprinted, so they have to register. But within 30 days of their 14th birthday, children they do have to register using the form G235R. And parents and legal guardians, its responsibility falls on them to make sure that their children are registered. So this is something that could impact your workforce, and it's important that employees understand this obligation for their children, um, and comply with it. Again, this kind of falls into just the theme that we've been beating on here is really processing times are through the board. I mean, especially for PERM, it's gotten really atrocious. It used to be 5 to 6 months for standard cases, 9 to 10 months. What we're looking at right now is about 16 months.
Yeah.
So if you're trying to retain your employees for permanent residency, it's better to start earlier. I mean, it's always good to start early, but right now it's almost essential to start early because this is not a process that you can hold off until, the fourth or fifth year of that person's eligibility. Because some visas, it doesn't matter necessarily. They can be extended indefinitely, but TN management consultants where extensions are difficult, H-1Bs who have a 6-year limit, L1s where they have a 5 or 7 year limit. You need to be cognizant of this because if you want to retain your talent, you've got to start earlier than ever before. Now, where all of this comes back to is really what we're seeing. The number one impact, I think, and we talked about it, the big beautiful bill giving millions and millions of dollars to ICE is essentially ICE has more money than most militaries in the world now. That we're gonna see these investigations. ICE, the I-9, I know people think, well, oh, that's not really immigration, that's labor and employment. It is immigration. It's part of the immigration law, and ICE is the agency that enforces this, along with Homeland Security investigations and FDNS and all the other agencies. We're seeing a huge surge in audit activity. The I-9s have completely spiked. The I-9 audits have completely spiked. And when we think of raids, we're thinking of the worst case scenario. That's not ICE's biggest tool. Their biggest tool is the audit. And what that is just an officer showing up to your workplace, giving you a notice, and you have to answer within 72 days. So what we're seeing right now is employers, whether they're big employers with I-9 policies that may have some gaps, or if they're small employers who don't even know what an I-9 is. It's a complex form. There's a lot of risk, and fines can go anywhere from about $300 to about $3,000 per violation. You're looking at a lot of money. So, 3 or 4 violations for a small employer, we're talking about $12,000, $15,000 in fines. It's a lot of money that's involved. And these and it's not just, oh, you didn't fill out the I-9s. Little errors on the I-9s can be substantive violations. They can cause fines too. So it's more important now than ever. If you don't have an I-9 policy, we train employers, all sizes of employers, small employers, big employers, how to set up your I-9s, how to do your policies. Please contact us. We're here for you to give you our knowledge and work with you on this. And if you have a big policy audit, or if you're a big employer, you have policies already, your policies may have gaps. If your internal audits show something, come to us. We're more than happy to give you strategies to address, happy to help you with the audits themselves and identify the gaps in compliance where you might be looking at thousands of dollars in fines. Really, what we're seeing from employers nationwide, what they're talking about is I-9 hell. And Sarah talked about the EAD revocations. 1 million people who previously had legal status or legal protection have lost their work authorization. 1 million people is going to affect a lot of employers. I know some of it may be impacting your business. We've seen a million questions about this since January, and we know how stressful of a time this is. People are scrambling. Things are changing day to day. New countries are having their statuses revoked on a day-to-day basis. We're here to help. We have what's a compliance guide sheet. We're more than happy to help employers that have workforces that you depend on these types of employees who had EADs and are now facing revocation, how to deal with this, because this is a stressful time. I mean, we're seeing some employers lose 30 to 40% of their workforce in certain offices or certain locations. So this is a big deal. And how you can deal with this as an employer, some steps that you can take: conduct your internal I-9 audits. Make sure your practices are shipshape. If they're not, we're happy to help. We're happy to audit them for you to make sure that they're good. Making sure that you develop response plans for raids. Again, please reach out to us. I know we've got our law firm friends, our general counsel friends, our business friends. Reach out to us. We have a compliance guide sheet. We're more than happy to share it with you. We're happy to teach you how, best practices for raid response, for investigation response, for your internal I-9 audits, how to train your HR on suspect or missing documents. I mean, right now, fake documents, things like that. One thing we are advising some of our clients: document copying. We used to tell them it's a great practice to do, but unless you're required to do by law, it may be a good time to revisit that policy, because that document copying now, with the way that with the I-9 audits are shaping up, with how ICE is investigating things, document copying is really not the best strategy that we're seeing. So unless you're required to do so by law, for example, if you're an E-Verify employer and you have to retain copies, you know, we think that it's really not the best, way to handle your I-9s.
But this is probably not the time to be throwing those away, right? Too.
Yeah.
So
Yeah.
we'll
So the other
provide,
thing is,
yeah.
yeah, if you've done them in the past, please don't throw them away. That's really important, Sarah. I'm glad you brought that up. Yeah, you don't want to destroy anything. If you had copies in the past, you weren't doing anything wrong, but if you're not required to keep copies, maybe going forward, then it's a good idea to transition out of that policy and keep what you have, but going forward, you're in compliance. You're not, unless you're, again, like I said, if you're an E-Verify employer, you're required to maybe do it. But if you're not required to do it, then the document copying may hurt you more than it'll help. Again, my final point, compliance guide sheet. We're here to give you information. We're here to share our knowledge. We're here to help you with your I-9 practices and your audits and your investigations and raids. So please, if you have any questions or if you're facing that, or if you like to be prepared, because preparedness is the best thing you can do right now. If you'd like to be prepared, Monty and Ramirez, we're here to help.
Yes, we are. And thank you so much. And for that, please stay tuned to the other, we plan on, and we promised you at the beginning of the year, we would be having 4 of these webinars. I think we're getting ready for at the end of the year to kind of tie up the year to show, where we've been. But please, wait, and we'll be sending out information regarding that I-9 for small employers, and we're going to do that in Spanish, okay? Because that I-9 is required of every employer in the United States, no matter how big and how small. So I think that's going to be an important one as well.
Yes,
Yeah.
absolutely.
Thank you for all of those. I see lots of people who are out there, and so glad that our clients, so many of them signed up. But keep in touch. You need any sort of information, need help on your audits, H-1B audits as well. Maybe we'll spend a little bit of time next time talking a little bit about the H-1B compliance.